Hello and welcome. My name is Jeremy Glover and it's my pleasure to welcome you to our latest Fenwick Elliott webinar. Today I'm joined by two of my colleagues here at Fenwick Elliott, partner Claire King and senior associate Beth McManus. And they'll be looking at the FIDIC form of contract, which, as you all know, is the most widely used form of construction contract globally. And in particular, Claire and Beth are going to be looking at the role of the engineer. Of course, strictly the engineer is the third party to the standard FIDIC Rainbow Suite form of contract, but they obviously play a crucial role in the contract and management process. And Claire and Beth will be looking at both the 1999 and 2017 forms, considering some of the differences between them. And one question we've been asked a lot recently is how much is the 2017 form of contract being used? Now, obviously, FIDIC has entered into a number of agreements with the development banks and only yesterday signed up an agreement with the International Fund for Agricultural Development, the IFAD. And so you can see projects using the 2017 form of contract going out to tender with the multilateral banks. So I think that the answer is that the 2017 form is beginning to be used. Maybe not so much yet in the Middle East, but traditionally take-up is slow there. That said, I think we've heard of one example in the GCC. Elsewhere, anecdotally, I know that dispute avoidance boards are being formed. So I think the message is the 2017 form of contract is now beginning to be used. So the roles and responsibilities of the engineer under the 2017 form will be of some significance. So before I hand over to Claire, just a reminder that as usual, you're all on mute, but please do send in any questions. And you'll also be able to find the slides on our website later in the week, a link we put in the chat function during the webinar. But Claire, the floor is yours.
Thank you very much, Jeremy. As Jeremy said, we're going to be looking at the role of the engineer in the FIDIC 2017 forms, the yellow and the red books particularly. The silver book obviously has an employer's representative instead. We're going to take a look at the qualifications that engineer needs to have, high-level duties and their authority, who is the engineer's representative, and can the employer's employee be the engineer, which is an interesting question submitted in advance. Then we're going to canter through, I'm going to canter through the engineer's role in contract management, some key features, instructions, the program as a project tool, meetings and risk management, payment and record requirements. And then Beth, I'm going to hand over to, is going to deal with the engineer's determinations and look at time bars and deeming provisions so far as they impact on the engineer. So who and what is the engineer? Well, clause 3.1, the engineer can be a person or a legal entity, so a company or a partnership perhaps. If they are a legal entity, then a natural person must be appointed to act on its behalf, and notice has to be given to the employer and the contractor as to who that individual is, and they are then authorised to act on the engineer's behalf. They have to be a professional engineer having suitable qualifications, experience and competence to act in relation to that contract and fluent in the ruling language. Now, this can cause difficulties for employers who perhaps would normally appoint project managers who are not necessarily engineers, perhaps because they may potentially be cheaper, unless the terms are amended. So a failure to appoint somebody with the suitable qualifications as required by the contract could technically be a breach of contract. So you need to think carefully about who you appoint. So clause 3.2 sets out the high level what their duties and authority levels are. They have to act as a skilled professional. They're deemed to act for the employer unless it says otherwise, for example, in clause 3.7, when they have to act neutrally. But they don't have unfettered powers, so there's no authority to amend the contract, and they cannot relieve anyone of any duty, obligation, or responsibility under the contract. Which is an interesting provision that arguably sort of sits slightly at odds with English law in terms of waiver and estoppel provisions, so something to think about. And the particular conditions should state if the employer's consent is required in order for the engineer to exercise any specific power. But if he does go on and exercise that power, it is deemed that he's been given that, which could cause issues if your engineer goes rogue. But importantly, no employer consent is required to make a determination, and that's really goes to the heart of the whole ethos of the contract, an early resolution of disputes with the engineer sort of stepping in to make determinations. And Beth is going to cover that later. And I think if you amended that provision, you would arguably be conflicting with FIDIC's golden principles and risk and how it's handled generally. So you'd need to think very carefully before you amended that at all. And as I said, nothing the engineer does will relieve the contractor of their obligations under the contract. So the engineer acts neutrally when making a determination, not impartially or independently, which is some of the old wording you see. And those words have been chosen by FIDIC deliberately to avoid issues in some civil law jurisdictions that have happened historically. Now, the word neutrally isn't used elsewhere in the contract, it's used in the determination provisions. So arguably, when they're doing interim or final payment certificates, for example, they don't have to act neutrally, although if they then have to go on and make a determination about what they've done, the neutral would kick in. So again, it's something to think about for the engineer. Under the contract, there's no sort of overriding duty expressly to act fairly or treat the employer or the contractor equally, and that's sometimes a misconception on that point. But such a duty can be implied by the governing law. With English law, contract administrators have to act in a fair and unbiased manner, and I've given you the case law for that. So if there's a different governing law, you should always check what the provisions are in relation to contract administrators generally in their role. So the engineer's representative in the 2017 edition has to be based on site the whole time the works are being executed. And the engineer can delegate powers to them. They have to be a natural person. And this reflects the increased focus on project management in the 2017 editions compared to past editions. But there are some really key powers that the engineer representative cannot be delegated. And those are determinations, which, as I said, Beth will go through in detail later, along with notices to correct under clause 15.1. And as that can be a first step to termination for default, it is quite a key power. So you can see why those powers have been reserved for the engineer themselves. So this was a very interesting question that was submitted in advance. Can the engineer be an employer's employee? There's nothing expressly within the FIDIC form that explicitly prevents this, but it doesn't sit well with how it's drafted or with the governing law if the governing law is English law. There's provision for express appointment of the engineer. Would you need to do this if it was just employee? Provision of the replacement of the engineer as well in clause 3.6. And the nature of the role itself doesn't really sit well with having somebody who is essentially the employer. How can they act neutrally in circumstances where they work for the employer? Governing law as well, and certainly English case law, suggests that the employer cannot assume the role of construction manager or decision maker unless you amend the contract to make express contractual provision for it. And they're the cases in English law that sort of set that out. But again, a query whether you'd want to actually do that under the yellow or the red book, it rather knocks the balance of how things work. And as a contractor, would you want to agree to that? So moving on, the engineer's role in contract management. As an overview, there is enhanced project management in the 2017 editions. The emphasis is on getting in there early and preventing disputes arising, or if they do arise, on early resolution of those disputes. So the engineer and the employer obviously need to be aware of the tools that are available for that purpose to keep things ticking over smoothly. The contract, for example, imposes strict requirements for communicating with the parties to avoid disputes on notices, for example, and also strict time limits for actions required by the engineer as well as time limits generally, and as I said, Beth will cover sort of time bars and deeming provisions later. It's a sophisticated role and there need to be sufficient and good enough resources available to manage that process. And we're now going to run through some of the key ones. I've done a list of some of the sort of engineer's duties. Now, we're not going to be able to cover all of those in the time we've got, unfortunately, but we are going to be looking at reviewing programmes, payment certificates, and various other risk management tools in terms of the programme advanced warning notices and other things that you can do to sort of get in there early and make sure things are ticking over smoothly. So the first one that came in the 2017 is the instruction provisions in clause 3.5. Now, under those, the engineer can issue instructions necessary for the execution of the works, and the contractor has to comply with them. But there's a big unless there, and the unless is a sensible unless, because it should get in there early and prevent sort of variation. Is it or is it not a variation? Does it do what it says on the tin sort of arguments at an early stage? So if the contractor considers that the instruction is a variation, but the instruction doesn't say that on its face, or it's not compliant with the laws, it's unsafe, it's impossible, then they have to issue a notice to the engineer immediately and before commencing works. The idea being that that's going to hopefully prevent money being wasted if, for example, the employer or the engineer didn't think it was a variation. The engineer then has 7 days to respond, or the instruction is deemed to be revoked. So it's helpful for the contractor because it's a way of challenging variations by the back door, and I think most people have seen that done in one form or another. But it's also helpful for the employer because money is not wasted before the works are commenced, and then you face variation arguments afterwards. The programme, there's some really helpful provisions on the programme if they are used properly. There are detailed provisions in there as the required contents of the as planned programme. The emphasis is on early detail, and you're definitely going to require in-depth collaboration with your subcontractors and suppliers from a contractor's perspective to get that up to the level of detail you want. The exact level of detail cross-refers to the employer's requirements. So again, you need to think about what's in the employer's requirements in terms of your programme, but it is meant to be logic links for all activities, showing any float, and review periods for submissions and things like that should all be in there. So the contractor is meant to submit that within 28 days of the notice of commencement, and the programme is to be provided in paper and electronic forms, which is very helpful because it obviously allows a deeper level of analysis by the engineer to ensure that nothing is hidden in that, and everybody knows what is linking to what and whether that's sensible or not. So hopefully you don't get silly arguments about whether something was a critical activity or whether something flowed on logically, who owned the float later down the line. The contractor also has to submit updated programmes whenever they cease to reflect actual progress or otherwise inconsistent with their obligations. So how does the engineer fit into that? Well, they have a duty to review the programme and to consider to what extent it complies with it in the contract. And I'd say that's quite an important thing to do really thoroughly right at the beginning. For a number of reasons. I mean, generally speaking, when we see disputes at the end of the line, if there's a poor programme or it hasn't been handed over or updated properly, the logic links don't work, the review periods would never have quite worked, they're not realistic, it all adds to the expense, well, either causes disputes in the first place or it adds to the expense of dealing with them. So the engineer has to look at it and he has to give notices within a fixed period if he doesn't agree with it or has any comments or it's deemed to be accepted. And again, that's helpful because you don't get into silly arguments about what is and what is not your baseline programme, both for the initial programme but also for revised programmes when you have extension of time claims potentially down the line. The engineer can also notify requirements for updated programmes when he considers that it ceases to comply with the contract, and then the contractor has to submit a new one within 14 days of that notice. So this is a really useful provision, a useful tool for managing the project properly, but you've got to ensure the project link logic is correct, sensible, and create a useful tool to actively monitor and manage that process. Other risk management tools available to the engineer are the advanced warning provisions under clause 8.4. The engineer can issue such notices as well as the other parties, it's not just the engineer, if there's something adversely affecting the work of the contractor's personnel and there's something adversely affecting when the works are completed, increasing the contract price or delaying the works generally. And then helpfully the engineer can request proposals to avoid or minimise the effect of these problems. So it's looking forward to bringing the parties together to try and minimise any effects. And linked with that is the engineer's ability to ask for a recovery programme if the programme is delayed, and this is key, and there is no extension of time due to the contractor. Then they can instruct this revised programme, and in that programme they can ask for revised methods for expediting the progress and completing on time. The costs are at the contractor's risk, and the contractor has to adopt it unless the engineer looks at it and notifies otherwise. And the employer can also claim for costs if they incur expense as a result of this programme. But this tool comes with a warning. If delays are due to matters that entitle the contractor to an extension of time, then the contractor will get their costs, because effectively you're asking them to accelerate. But yeah, revised methods are going to be acceleration. So this is a very useful tool potentially, but you have to use it carefully and be very sort of clear as to extension of time entitlements before asking for it, if at all possible. Otherwise, there's potential you could end up in dispute as to who's going to pay for the costs of this programme. Meetings, also a useful tool. The engineer can retire attendance to meetings of the contractor's representatives, but also the contractor, other contractors, subcontractors and suppliers, and keep records and supply them to others. All the actions have to be in accordance with the contract, but you can get people in a meeting, perhaps after you've warned of an advance, given an advance warning of a particular risk, discuss it, get everyone together to mitigate that risk. So again, it's a really useful tool potentially. And we see some clients using that in conjunction with risk registers. Perhaps they amend the contract to reflect that, so that risks can be identified. You all agree a plan of action to try and reduce any delays or costs. Records. This applies where claims have been notified, so clause 20.2.3, but it's again for the engineer it's useful to think about, but also for the employer and the contractor. So the engineer may monitor the contractor's contemporary records after events giving rise to a claim, instruct the contractor to keep additional records, inspect those records, normally during working hours, and ask for copies. Now, there's no implied acceptance as a result of inspecting the records, but if you think about this from the employer's perspective, it's a useful tool to sort of manage, to monitor how claims are going, or what the quantum or length of delays relating to those claims is. They may want to do that potentially in relation to COVID claims that are going on in various jurisdictions at the moment. And also with the contractor, perhaps you want to try and agree the format of records to get the employer's buy-in with the disruption or lack of productivity that's sort of associated with COVID. It can be hard to argue, to get all your records in a row and produce the claim in the level of detail you want. And obviously, if you've got people agreeing things as much as possible, what you want to see to validate those claims, they're harder to reject at a later date. So finally, before I hand over to Beth, payment. The engineer is much more involved in the payment provisions than in previous editions of FIDIC. Applications for payment, the statements are meant to be in a form acceptable to the engineer. So obviously, if the engineer has any concerns, the level of detail isn't there, there's not the sort of visibility or the audit trail in those statements, then that's something you want to deal with early doors. But also the engineer can revise the instalments of any payments if, for example, instalments are not defined by reference to actual progress achieved and the actual progress then differs to the schedule of payments. That's something they can help with. But crucially, the engineer has to give reasons and details of its calculations if it withholds any payment, so the contractor can see and understand why it's not being paid. If with payments are withheld, then the engineer must give reasons and details of its calculations. But that helpfully there are provisions for challenging errors. So the engineer himself may correct or modify errors in the next interim payment certificate. The contractor can challenge anything withheld in the next statement. And the contractor may also refer the matter by giving a notice under clause 3.7, which is when you go into the determination provisions. And at that point, the engineer has to act neutrally. So that's something to think about. So those are some of the key project management tools of the engineer. With that, I'm going to hand over to Beth, who's going to talk you through the engineer's determination.
Great, thank you, Claire. Okay, I should now have control of the slides. We'll see how that goes. As Claire mentioned at the start, I'm just going to take us through the engineer's determination and also spend a little bit of time on time bars and the deeming provisions that tend to go hand in hand. So the engineer's determination, we begin with subclause 3.7 in the 2017 Yellow Book, which is the same as the red, broadly the same as the Red Book as far as it comes to the engineer. So in the Yellow Book, new subclause 3.7 agreement or determination replaces the previous subclause 3.5 in the 99 edition. And it sets out the procedure the engineer has to follow when it is agreeing or determining either time or money claims, claims for any other entitlement or relief, so not time or money. This other entitlement or relief could be any kind whatsoever. So the examples they give are including in connection with any certificate, determination, instruction, notice, opinion or valuation of the engineer. And it also, subclause 3.7 also relates to any matters that the contract expressly provides to be referred to in the engineer, referred to the engineer, which slightly scoops up any claims that don't fall within the previous two categories. I would just note that the second category there is actually a new provision in the 2017 suite, and the parties are no longer able to refer this type of claim directly to the Dispute Avoidance and Adjudication Board as they would have been able to under the previous versions of the suite. Okay, so under subclause 3.5 of the 99 Yellow Book, the engineer was under an obligation to consult with the parties to endeavour to reach agreement when there's a dispute. This obligation is retained and it's expanded upon substantially in the new subclause 3.7, which imposes a much more detailed procedure as well as additional time limits on the engineer when agreeing or determining any matter or claim. The new procedure expands upon the pre-arbitral steps. So it includes a mandatory additional 42-day period in the engineer's determination, plus an extra 28 days to issue a notice of dissatisfaction, which is what the parties submit if they're not happy with what the engineer has decided. So the aim of these really is to resolve the disputes between the parties at an early stage so as to avoid the need for a DAB decision or an arbitral award. And subclause 3.7 consists of 5 sections, which I've just set out there. The first section really is the obligations to try and reach agreement, try and consult with the parties and see if they can be moved towards each other. And there's a set period in which the parties can do that. Then if agreement's not reached, 3.7.2 concerns the engineer's determination. Point 3 is the time limit. Point 4 is the effect of the agreement or determination, and it also provides for what happens if there are any errors in the engineer's determination. And then 3.7.5 provides for the next step. So what happens if the parties aren't happy with the engineer's determination? So 3.7.1, this is the obligation to consult to reach agreement. And it imposes new requirements on the engineer to consult with the parties jointly and or separately to encourage discussion so that they can reach agreement. And it sets out a 42-day time limit for such consultations. And it also provides for the engineer to provide a record of the consultation to the parties unless it's otherwise agreed. So continuing on this obligation, if within that 42-day time limit an agreement is reached, the engineer has to issue a notice of the parties' agreement. And if no agreement is reached, the engineer issues a notice of no agreement and then immediately proceeds with the engineer's determination under subclause 3.7.2. If the engineer gives the notice of the parties' agreement, this has to be signed by both parties, and it has to state that it is a notice of the parties' agreement on the face of it, and it also must include a copy of the agreement. However, if no agreement's reached, like I say, clause 3.7.2 comes into play. I would just say that it's worth noting that the time limit of 42 days, it can actually be amended if an alternative is proposed by the engineer and then agreed to by the parties. But it looks from the way that the contract's drafted that this has to be subject to the engineer's proposal. It doesn't look like, well, the contract doesn't provide for it to be proposed by the parties. It simply allows them to agree to the engineer's proposal. So next slide is just the engineer's determination. So if no agreements are reached within that 42-day period, the engineer is required to make a fair determination of the matter or claim in accordance with the contract and taking due regard of all relevant circumstances. So if no agreements reached in the initial 42-day consulting period, the engineer is given a further 42 days to make a fair determination. So the practical effect of these changes is that the time in which the engineer has to make a determination has actually doubled from the previous versions of the suite of the Yellow Book. So it's doubled to 84 days in total, whereas under the 99 version of the Yellow Book, the engineer was obliged to consult the parties and also to make the determination within one 42-day period. So this can be viewed negatively in that it lengthens the overall procedure for resolving disputes. It adds at least 42 days onto that. But it can also be viewed positively in that allowing that extra time, the aim of it is to allow the parties to reach a closer agreement and allow disputes to be resolved, hopefully to everybody's satisfaction. And the idea is that allowing a bit more time for that should increase the likelihood of the dispute being resolved and thus reduce the likelihood of having to have recourse to the dispute resolution procedures or provisions under clause 21. So if the engineer then has to give a notice of determination, it has 42 days in which to reach its decision and to issue this notice. And the notice, again, it has to state on the face of it that it is a notice of the engineer's determination, and it has to describe the determination in detail, not just with the supporting particulars that would have been required in the 99 edition, but also now the engineer must expressly give reasons for its determination under subclause 3.7.2. So the effect of, oh, sorry, I skipped on there. Yeah. So if the engineer doesn't give this notice of agreement or determination within that 42-day time limit, it's deemed essentially to be a rejection of the claim. So it's either, in the case of a claim, it's if no notice of agreement is given, it's deemed to be a determination rejecting the claim, and if it's a matter to be agreed or determined, then it will then be deemed, if no notice of agreement or no notice of determination is given, the matter will then be deemed to be a dispute. And no further NOD. An NOD is a notice of dissatisfaction, which would otherwise be given if a party disagreed with the engineer's determination. So this NOD isn't required if a matter that is to be agreed or determined does not have a notice of agreement or determination issued in respect of it, then it becomes a dispute and no notice of dissatisfaction is required to be submitted in order for this to be escalated to the Dispute Adjudication and Avoidance Board. And yes, subclauses 3.7.5 and subparagraph A of subclause 21.4.1 will not apply in these circumstances. So subclause 3.7.4 sets out the effect of the agreement or determination. And essentially this provides for circumstances in which either the parties or the engineer identify that there's an error in the engineer's agreement or determination. So there's a 14-day window to identify any error, and it's not aimed at the large errors, it's aimed at errors of typographical, clerical or arithmetical nature. And if the engineer identifies the error, then he has to, or she has to immediately advise the parties. And if the party identifies the error, they have to give notice to the engineer, stating that the notice is given under clause 3.7.4 and also clearly identifying the error. And the engineer then has 7 days to correct the error. That's 7 days from either finding the error or being notified of the error. And once the error is corrected, the engineer will give notice to the parties of the corrected agreement or determination. And the interesting point to note here, to be aware of, is that once the determination is corrected, it is then treated as the determination for the purpose of the conditions, which is relevant because time limits will then run from the date of the corrected determination and not the original document. So if either party is dissatisfied with the engineer's determination, under new clause 3.7.4, it may, within 28 days of receiving the determination, or if the engineer does nothing and doesn't circulate a determination, within 28 days of the expiry of the time limit in which it could have issued a determination, then the party that's dissatisfied must give the other party a notice of dissatisfaction with the engineer's determination and copy this to the engineer and also set out its reasons for its dissatisfaction. And it's really important for the parties to note that failing to give this notice within the 28-day period means that the engineer's determination will in fact be deemed to have been accepted finally and conclusively by both parties. So there's only a small window in which a notice of dissatisfaction can be given, and if it's not given within that timescale, the determination is final and binding. There's no equivalent provision in the 99 Yellow Book, and in that 99 Yellow Book, the engineer's determination is said to be valid unless and until revised under subclause 20. And there's no corresponding risk that we see in the 2017 Yellow Book that a party might lose its right to make a claim further up the line. And the aim really of this is just to ensure that claims and disputes are dealt with as they arise, rather than being left until the end where the parties have to go and scoop up all the details and may not have the best of records and may not have the best of memories. So it's aimed at getting these dealt with as the project goes along. So given how important the notice requirements are, or how important it is to get your notice in within the time limits specified, there's an awful lot at stake, and both parties and the engineer should be aware of the formal requirements for giving notices and other communications. So this is actually set out in clause 1.3, so a bit of a departure from 3.7, but it is really worth getting to grips with the detail of that clause because it will determine whether your notices are validly given and therefore whether, for example, the engineer's determination is binding. One particular point to note is that if a notice or a notice of dissatisfaction or another communication is sent by email, it is deemed received the day after transmission. So basically, if you're going to send a notice by email, you really should make sure to send it the day before, at least the day before the expiry of any deadline, so that if there's some technical issues or for some reason your email isn't received by the other side, as long as you can show that you've sent it, that you've transmitted it, then you can rely on the contract to deem that delivery took place, to deem that the contractor received the actual documents. And just as a brief overview, the recourse to the DAB is much more tightly controlled under the 2017 suite, and a dispute just cannot arise under the contract unless and until the clause 3.7 process for determining claims has been completed. And even then, only if a notice of dissatisfaction has been given within the required period, or the engineer fails to give its notice of determination within the required period. And I've just got quite a useful flowchart just for your reference that sets out the procedure to be followed for the engineer's determination and any subsequent referral. And I've got a couple of scenarios here that I can just quickly take you through, where you can see in this scenario one, using the flowchart that's set out above, if the engineer starts performing its consulting duties under subclause 3.7, if the parties then reach agreement within that 42-day period, you can see that the timescale for all these steps starts becoming a little bit compressed. But basically, the parties reach agreement in that 42-day period. The engineer subsequently issues a notice of agreement. An error is picked up within 14 days. It's corrected within 7 days. And that's the shortest the process would be, where there's then no notice of dissatisfaction issued, and the whole dispute is just wrapped up quite quickly. Scenario 2 and scenario 3, I will let you have a look at on your own time. I don't want to take up too much time looking at it, but you can see how the timescale starts expanding if you start pushing to the outer ends of those time limits, and also if further errors are corrected and picked up at the outsets of those time limits. And just briefly to pick up on time bars and deeming provisions, there's an important difference between time limits and time bars. Time limits provide that a party should act within a period of time, whereas a time bar provides that a party must act, and if it doesn't do so, it loses certain rights. Now, there are a number of time bars within the contract relating to various topics, but there are five specific time bars that relate to the claims and the disputes resolution process, and which therefore have the engineer involved to greater or lesser degrees. So, if the party fails to comply with the relevant time period for notifying an initial claim, this time period should be no later than 28 days after the claiming party becomes aware of the circumstances giving rise to the claim. But if it doesn't notify within those 28 days, the claim may be rejected. I would note that it is open to the engineer to waive the requirement for notification within that time period in extenuating circumstances. We also have providing a statement of the contractual or legal basis at the point where the contractor is submitting a detailed claim. If it leaves out that information within the time period of 84 days, then again, the notice of claim can be deemed to have lapsed and is no longer valid. But again, this may be waived by the engineer in extenuating circumstances. And, giving a notice of dissatisfaction in respect of the engineer's determination. The timescale here is 28 days after receiving the engineer's notice of determination or the engineer's notice of corrected determination. If the NOD isn't given in the timescale, the determination becomes final and this cannot be waived. The dispute then cannot be referred to the DAB for a decision. And just briefly covering off, referring a dispute to the DAB after giving a notice of dissatisfaction. The applicable timescale is within 42 days of giving or receiving a notice of dissatisfaction. And with the final category, giving a notice of dissatisfaction in respect of a DAB decision, so this is a sort of much later stage of the process, the notice of dissatisfaction should be given within 28 days. Otherwise, the decision becomes final and binding and neither party can bring the dispute to arbitration then. And the last two cannot be waived. And just briefly to run over deeming provisions, the time limits that are set out in the 2017 suite are often used together with deeming provisions so that if the time limit isn't complied with, an automatic consequence follows. There are several new deeming provisions in the 2017 suite which make consequences automatic, and it's FIDIC's view that these will provide more support for less experienced contract users, help the parties understand what's required, be easier to interpret, and result in fewer disputes over the life of the project. It's more prescriptive, but this can be helpful in many ways as well. And I'm just going to set out here a few examples of deeming provisions. So I've got about 5 examples there where there are deeming provisions that specifically relate to the engineer, but like I said, they are just examples for you to have a look at in your own time. And I think that takes us to the end of my section. So thank you.
No, well, thank you, Claire and Beth. That was a very thorough, very comprehensive review of the obligations of the engineer. And I think what that's your talk that showed to all of us is just how onerous potentially the role of the engineer has becoming under the 2017 form of contract. I mean, everyone jokes about the contract being twice as heavy, twice as long, etc., etc. But one of the reasons for that is because of the enhanced obligations of the engineer. And I think that's something that's very important for the engineer and the contractor and the employer to bear closely in mind. Understandably, we've had a number of questions, and there's just time for 2 or 3 of those. Beth, you spent some time going through the engineer's determination. I think that was a very sensible thing to do because sometimes it's an issue that is overlooked. But the reason it's overlooked is because of the presence of the DAB. And obviously that's there to resolve disputes where the engineer is already going to have given a decision. Is there any professional or contractual relationship with between the engineer and the DAB? Should there be? What's the difference, the distinction?
Well, largely, if you're looking at the DAB, which is obviously going to review any decisions that the engineer has made, and with that in mind, you don't actually want too close a relationship between those parties. I mean, obviously, it's helpful if relations are cordial, but you don't want. Ideally, you want the DAB to be an independent third party, and you want parties to take care to make sure that there's no conflict of interest or risk of conflict of interest. So I'd say there's no specific role set out in the 2017 Yellow Book referral of a dispute to the DAB. There's no specific role set out in that clause for the engineer. And I think taking it overall, I think any contractual or professional relationship would be minimal. You don't really want the two parties overlapping or having well, being too closely entwined, I would say.
Yeah, I mean that yeah, I think I'd agree with that. That sounds spot on. Claire, I've got a slightly left field question, but it's not related to some of the things we talked about. Terminating the engineer, I mean, can the employer do that? And is there any, I mean, I don't know if there's any differences between the various forms of contract. I know it's not something that we touched on sort of too much, but I mean, I don't know if you've got any comments on the ability of the employer to do that.
Well, in terms of terminating the engineer, you obviously first of all need to look at what's in your contract with the engineer directly, if you're the employer, because you don't want to be breaching the underlying appointment. So that's the first thing to bear in mind. I did look at this briefly because there was a question on the 4th edition 1987 form, and there isn't anything in that form that I could see from a search in relation to terminating the engineer and getting a replacement. But there are express provisions in this 2017 editions for replacing, and there's sort of various notification periods. So it's 42 days the engineer can be replaced in, but the contractor has a right to reject their replacement if you terminate and replace with somebody who they don't consider to be appropriate. And as I said, I don't think it would be appropriate without express contractual amendments, certainly under English law anyway, to have an employee of the employer, which I know does happen sometimes. So that's something to definitely be aware of in terms of terminating. So I think under the older forms, there's not such a rigid structure for how you would go about it. You'd want to be doing it with consent, and I think it would be difficult to appoint your own guy. You'd want somebody independent. Yeah,
no, I mean that makes sense, and of course, FIDIC would be hoping that everyone's used the White Book consultancy agreement for the employer to appoint the engineer. Just time for one final question. To what extent does an engineer, if at all, I suppose, have a supervision role under the FIDIC form of contract? I don't mind, Beth.
Yeah, happy to do that. The FIDIC, the Yellow Book, the 2017 Yellow Book doesn't use the language of supervision. It doesn't particularly use that term. However, it does include several obligations on the contractor. Sorry, on the engineer to review or to monitor various items under the contract. So just by way of an example, or a few examples, the obligation to review, and I would, sorry, to take it in better order, I would just point out that review is actually defined under the contract, and it's defined, let me just get it. It means examination and consideration by the engineer of a contractor's submission in order to assess whether and to what extent it complies with the contract and or the contractor's obligations under or in connection with the contract. And this, so I mean, it sounds broadly similar to a sort of supervisory role, and although it doesn't use that language. And the obligation on the engineer to review extends to review of the quality management system, of the contractor's proposals for remedial works, of the initial program and any revised programs, and any proposed test programs for tests on completion. And that's quite a, I mean, it's getting towards a supervisory role.
Yeah, it is, isn't it? I mean, there's sort of quite, I mean, and I suppose that the other issue, and it's the issue that you finished on, that in a number of cases, if they don't carry out the review within a required timescale, then the deeming provisions that you were talking about at the end of your talk are very much going to come into place. So I think that's another warning for the engineer, sort of, you know, follow those deadlines and make sure that you do what's required within those deadlines. Well, I think we've just about run out of time. So, but thank you very much, Claire. Thank you, Beth, for, as I've said, it's an extremely thorough presentation on a topic that's not always given the attention I think it deserved. And I think you've both demonstrated, particularly under the 2017 form of contract. It's something that needs to be taken very seriously indeed. So thank you both. Thank you all for attending. Thank you very much for your questions. Our next webinar on fortnight's time, 12 noon on Thursday, as always, 17th June. We're looking at variations and delay, and Lyndon Smith, partner at Fenwick Elliott, will be joined by Mark Wilkins, a senior associate, talking about variations, delay. Nothing ever stays the same. So hopefully you'll be able to join us then. In the meantime, enjoy the sun. Enjoy it. Well, if you're in the UK at least, enjoy the weather.